Welcome back. Let's talk about human rights issues. What latitude the Constitution provides and what the limit of those rights. And there's been a lot of talk concerning the issue of Dele Farrow to me, which has generated public interest. Some for and against. Others have said, Are Afe Babalola has built his career for 60 years. He's 95 years old. And this case is more like looking at him writing his history from the very end, which he has to defend himself. The issue about defamation being whether a criminal or civil case, as is provided in Nigeria, has also the issue of 3 states decriminalizing defamation, including Lagos, Edo, and we understand Ekiti. So there's been a lot. Without trying to get into the merits of the case, that is left for the judges to decide. We just want to look around the issues of human rights and whether there were abuses or breach of those rights as well. Picking back on Dele Farrow to me's case, as well as some arrests that have been made recently by the police and some persons cursing or using threatening or literally, in the words of the police, inciting people to attack the police. So as much as time will allow us, we'll look at all of this. We're being joined in the program by a legal practitioner, Mr. Michael Ajay. He joins us from our Bojo studio. Mr. Ajay, thank you so much for coming on the program.
Pleasure's mine, sir.
So maybe help us clarify this issue of defamation, criminal and civil defamation, because the criminal code, at least in the southern part of the country, provides for that. Because sometimes people are a bit not sure or what the law says. So you are the legal practitioner here. So what is civil and criminal defamation, and what is the implication of all of this as provided in the law?
Yeah, so defamation is can be approached in 2 folds, the criminal and the civil, like you rightly said. The penal code and the criminal code, respectively, have made provisions criminalizing issues of defamation. Where that occurs, the criminal legal system would take its course. Now, for civil defamation, the person who is defamed has a right to approach the court for damages or seek redress in tort. So that is basically the difference. For criminal, the person who perpetrated the defamatory conduct would be arraigned before the court and go through all the gamut of criminal prosecution and all of that. So the criminal code and the penal code have respectively made ample provisions with regards to that. So basically, one, you would seek civil claims in the court for damages, for example, and all of that. And the thing is that you would wonder why people would not even prefer to go to make a civil claim where you can make claims for millions of naira and all of that. Why would they prefer to go for the criminal prosecution of defamatory issues? So I think that is left for us to assess. Thank you.
Okay, so let's look at because I'm trying my best as a lawyer. You're the legal practitioner. You know that we can't speak to the merit of the case because it's subject to under adjudication. We're just looking at the peripheral issues here. And one of the issues that was raised, I was listening to a senior lawyer, and he talked about the fact that the magistrate court, now talking about the Dele Farrow to me's case, the magistrate court is a court of summary jurisdiction, while the other courts above it are courts of records. By implication, if I understand what he's trying to say, he's saying that, look, the issue of bail and on that premise is what he was questioning as to why the magistrate had to ask for a written bail for Dele Farrow to me because it's a court of summary jurisdiction. I would like you to speak to that. And he also cited the fact that there are simple offenses, there are misdemeanors, and there are felonies. And this, at its best, may be a misdemeanor. It doesn't require some of the stringent measures, in his view, of what is required. And this maybe speaks to a level of high-handedness, allegedly. What's your view?
Yeah, so the judges have discretionary power, wide discretionary powers to hand down their judgment. So the case would be treated as a misdemeanor. But in terms of bail, facts must be put into consideration. So because the judges have, the discretionary powers to admit somebody to bail or not, and also on what circumstances, what conditions should the person be admitted to bail. Now, the court would be considering proximity to where the person stays. For example, if he stays outside of the state, of course, possibility of the person coming back would also be a consideration. Possibility of having this alleged offense continuing, and the impact would also be another consideration. So the issue here is whether the discretion of the judge was exercised lawfully and all of that. You cannot question the discretion. That's why it's called the discretionary powers. So having considered all the facts placed before the judge, he would determine what is best. So that's the difference between taking a look at this circumstance from a legal standpoint and from a non-legal view. So those surrounding circumstances, the frequency of this offense, and whether the person is even repentant, whether the person is living within the jurisdiction of the court, and several other things are part of the considerations that the judge would must have taken cognizance of in delivering that the ruling for bail.
So are you saying that despite being a court, an inferior court and a court of summary jurisdiction, the judge has a right to ask for a written bail application? I just wanted to be clear on that.
Yes, nothing is actually stopping the court. Like I told you, the discretionary powers of the court is so enormous. He has the discretion to even refuse the bail, even if the law says this particular offense is bailable. Now the court would take into cognizance surrounding circumstances, like I said, and would those would inform the judgment, the mind, the decisions of the court. So the court is still within its right to say we need a written bail application. So it's left for the lawyers to argue whether a written application could be dispensed with. But as far as towards the pronouncement of the court, they would really have limits to what they can do. The best that anybody can do in the circumstance would be to proceed on appeal if they felt that the circumstances or the conditions for bail were enormous.
I'm going to move on from that in a moment, but I understand that issues around bail, you guide me if I'm wrong as a lawyer, it has to do with both policy and legal issue, given the fact that prisons are overcrowded, and the infrastructure, we need to be able to hold them. So they want to hold the right set of people, not just simple offense or misdemeanor that at maximum maybe 2 years imprisonment and all of that if they are found guilty. So that's why perhaps they said it's an issue of policy as well. Maybe you can comment on that. But moving on, there's this issue online that has been causing this back and forth between the spokesperson of the police, Muyiwa Adejobi, and he talked about, in fact, that raining curses on someone is an offense. I think he called it cyberbullying. I've forgotten how he referenced it. And that, I think somebody has even been taken into custody to that effect. I think from cursing the IGP, the president, or the president's son and himself and all of that. Cursing, first, is that still within our law? Because there was an argument that part has been repealed. So it helped me out. Has it been repealed too? How justiciable is cursing someone? Because even some of us, people curse us online. Just help us out here.
Yeah, so I have read, I've read on Twitter, most of those conversations and the comments that people have made and all of that. Now, a juxtaposition of Section 39 of the Constitution, which provides for the freedom of expression and the the freedom to hold opinion, and Section 24B of the Cybercrimes Act is where the problem is actually. Now, the Constitution, which is the ground, which is superior, had made provision empowering Nigerians to freely express themselves and to also hold, to have that freedom of thought, conscience, and all of that. But now the National Assembly also made the Cybercrimes Act, which in Section 24B had made provisions tending to qualify or restrict the position of the Constitution. Now, in the Cybercrimes Act, like I talked about, that Section 24B has provided that where somebody makes inflammatory comments, whether they are insults or comments intentionally or knowingly, knowing that those would, cause damage, create unrest and all of that, the person would, upon conviction, there's a penalty for 7 million and 3 years imprisonment. Now, there's a law actually, and that is what is informing this new dimension of of gagging people, especially on the social media. Now, where the problem is and where the problem should be addressed actually really is the legislature. The legislature should take a look at this law again and see whether this law needs amendment. Now, if I to share a personal opinion, I would want to say, okay, does this law is this inconsistent with the provisions of Section 39 of the 1999 Constitution? And where the court finds that inconsistency, it will automatically be null and void. So that will be an assignment for people, activists, lawyers, and civil society organizations and all to approach the court and say, this Section 24B, we need an interpretation. We need to know whether it's inconsistent with Section 39 of the Constitution of the Federal Republic of Nigeria, 1999. Thank you.
So are you saying by your submission, you have a feeling that Section 24B of the Cybercrimes Act, I wish I could get to it, is perhaps in conflict with Section 39 of the Constitution that gives that liberty to freely express oneself, juxtaposing it with Section 45 that gives latitude, the level of latitude someone has to the freedom of whatever freedom you choose to have?
Yeah, that's a point. It's only the court actually that can make that pronouncement. But I mean, for me, I would say, can the Cybercrimes Act, which is an inferior legislation, can it qualify the provision of the Constitution itself? If the Constitution has provided that it is supreme and every other law that is, inconsistent with it is null and void. Now, the question right now is the Constitution has provided, Constitution and international conventions and all that, and law have made ample provisions for the freedom and civil liberties of people, right to freely express themselves, right to freedom of assembly, right to hold thoughts, opinion, religion, and all of that. Now, if the Cybercrimes Act appears to gag it, appears to qualify it, appears or to be inconsistent with the provision of the the 1999 Constitution, then it's a responsibility for all of us, civil society, as well as citizens, to approach the court for a just determination. Thank you.
Because a lot of people will see this as draconian. I've been able to get to the provision of the law. I wish I could put it up, but I don't have it up. But let me read the Section 24 says, a person who knowingly or intentionally sends a message or other matter by means of computer systems or network that in B says he knows to be false for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred, ill will, or endless anxiety to another and cause such a message to be sent commits an offense under this act and is liable on conviction to a fine of no more than 7 million naira, imprisonment for a term of no more than 3 years or both. How do you qualify insult or needless anxiety? Because some of the words used here, you are the lawyers, wind down. How do you qualify? If I go to a judge and say how do you qualify that to send somebody to jail for pay 7 million naira?
Yeah, so where you read in section 24, 24A talks about whether the person intends, whether he knows, that the information that he or she is passing or resending or retweeting is capable or is false, is capable of misleading, and all of that. Whether the person even knows that that particular information is capable of being injurious to the other person. So the onus of proof actually lies with the prosecution. And that is where, the defense, would come in. So how can you say that the person knows? Have you done, a mental evaluation? Have you done forensic examinations and some other, factors to justify, to know with certainty that this person knew, per time that the information was false or the information was capable of causing annoyance and all of that. So I think that is where the legal battles would, begin.
Okay. I'm going to look at this, and we're going to walk and talk about this a lot more, because if not, we're going to see all kinds of litigation. And our worry as media professionals is that we don't want people to rely on some of these provisions of the law to begin to gag people to express themselves, as much as we know people must be responsible for their action and act responsibly. But we must thank you, Mr. Michael Eje, legal practitioner, joining us from Abuja today. Thank you, sir.
My pleasure.
And that's it on the program. Thank you so much for your time and, of course, your usual company. I'm Jeffrey Uzama. Have yourself a beautiful night. Bye-bye.